Welcome back, everyone. I hope everybody was able to enjoy some lunch and a little bit of respite from all of this information and learning. I want to thank everyone again for sticking with us through some of our technical difficulties, and I hope you all enjoyed the panel with Teresa and Amanda and Christy and Judge Fairbanks as much as I did. Our next panel is on a case study, ICWA in practice. Our speakers are Leah Lopez, a social worker with the Isleta del Sur Pueblo, and John Williams, an attorney who represents Isleta del Sur Pueblo. Throughout this presentation, the speakers will be using the poll feature, so please be on the lookout as they prompt you. You'll see a pop-up button, a pop-up window where you'll be able to enter your answers for the polls. And now I will have, Leah, if you're able to, there we are, I will yield the floor, and I believe you're both still muted. Thank you so much.
Good afternoon, guys. Thank you for being here.
Good afternoon, everyone. It's probably a little bit of a challenge that we're going to be doing this presentation right after lunch, so we hope that you all are still awake, and we're going to try to keep it as interactive as possible. So like Jocelyn said, my name is Leah Lopez. I am the Social Services Coordinator with Isleta del Sur Pueblo, and this is John Williams. He is our beloved child welfare attorney, and today we have a presentation for you, ICWA in practice. We're going to be going over some of the details of the ICWA law and go over some case scenarios with you. I am trying to get to the next slide. So our first question is, why do we have ICWA and different standards for Native children? And a poll question should be popping up. When you select the answers from the slides, I don't know if you all can see the slides still, but the answers were on the slides, or the questions, I'm sorry. And there's multiple choice, so you can select all that you feel apply. We're going to give you about a minute to answer.
Leah, I think that they can't see the slide answers, so would you mind reading off what the question and the answers were?
Yes. So the question is, why do we have ICWA and different standards for Native children? And the first one is, an alarming high percentage of Indian families are broken up by the removal of their children from them by non-tribal agencies and placed in non-Indian foster homes and institutions. The second one is, agencies have often failed to recognize the essential tribal relations of Indian people and the cultural and social standards prevailing in Indian communities and families. The third one is, there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children. The fourth one is, to protect the rights of the Indian child as an Indian and the rights of the Indian community and tribe in retaining its children in its society. And the fifth one is, to ensure that when possible, an Indian child should remain in the Indian community and ensure that Indian child welfare determinations are not based on, quote, a white middle-class standard, which in many cases forecloses placement with a Native family, end quote.
So Leah, your results are on the screen. And you had 53% say 2, 49% answer number 3, 36% number 4, 42% number 5, and 43% number 1. So pretty much an equal distribution of your answers.
Great.
And they all apply, because that's the reason that we have ICWA is for every single one of those, right?
Yes,
All
I am
right.
trying to click to the next slide. I'm so sorry.
Kind of what we envision doing now is once we get to the next slide, I'm going to kind of trot through the law and give you a quick overview and tell you what laws apply, kind of where to look for them, and then we will go over them again as we are actually going through the case scenarios. So one of the main elements of ICWA is reason to know and notice. According to ICWA, anytime there's an involuntary proceeding in a state court where the court knows or has reason to know that an Indian child is involved, the party seeking the foster care placement or termination of parental rights to an Indian child has to notify the parent or the Indian custodian and the Indian child's tribe. It's got to be done by registered mail with return receipt requested. And that is going to be a very important part of what needs to be done and what should be done really immediately. And we will go through that in our practice. But let's go to the next slide.
Sorry,
Oops.
guys.
Sorry about
All right.
that.
Next slide.
I'm trying. Tanya, I don't know if you can do, there we go.
There we go. So the last slide was the U.S. code. For the lawyers out there, the U.S. code site for ICWA is 25 U.S.C. 1901. The Code of Federal Regulations that apply to ICWA that give you guidelines on how to apply ICWA are 25 CFR. We're going to go over this one in a little more detail, but how does the state court determine if there's a reason to know the child is an Indian court? The court must ask each participant whether the participant knows or has reason to know that the child is an Indian child. The inquiry is to be made at the commencement of the proceeding, and all responses should be on the record. State courts must instruct the parties to inform the court if they subsequently receive information that provides reason to know the child is an Indian child. Next slide. Basically, if there's reason to know, the court's got to treat the child as an Indian child. The agency needs to confirm that the child is an Indian child, but until that confirmation is made, you've got to treat the child as an Indian child. Let's go to the next slide. Any participant, how do you know if the child is an Indian child? Any participant that informs the court that it's an Indian child, you look to see if there's any other discovered information that he's an Indian child. Where does the child live? If the child lives on a reservation, the parents live in a reservation, maybe the parents were born on a reservation, the child was born on a reservation, the child was a ward of the tribal court, somebody has a ID, a tribal ID, there's reason to know. Anytime anybody claims, next slide, please. Basically, anytime there's a reason to know, anytime any participant in the proceeding indicates the child has Native heritage. So if the parent says, I have Native heritage, even if they're not sure what that heritage is, even if they list a whole bunch of tribes, there's reason to know and the department has to give notice. Let's go to the next slide. What are the notice requirements? The party seeking placement, which is almost always CPS, has to send notice of each child custody proceeding. So every child custody proceeding, not just at the beginning, you have to send notice if it's an Indian child. The original and a copy needs to be filed with the court and along with proof of service. It's got to be sent to each tribe where the child may be a member, the child's parents or the Indian custodian may be a member. We've had cases where the parent says the child is Cherokee or they have Cherokee. So you've got to not just send notice to the Cherokee Nation in Oklahoma, you need to look under the Bureau of Indian Affairs and find all the tribes that have Cherokee in the title and send them notice as well. It's got to be sent by register or certified mail. It's got to be in clear and understandable language. One thing that I've noticed almost everybody screws up on is there are tons of things in this statute in the regulation 25 CFR 2311. Make sure that you provide all identifying information in the notice, and there is a clear statement of rights that's supposed to be provided in each notice. There is in the resource guide that y'all get, there is an organization, I think it's called NARF, and the site is there. NARF has a great 5-page notice that includes everything that is in the CFR. Make sure that gets done. Next slide.
Oops.
Sorry, I'm kind of speeding up through these, but we got a lot of ground to cover. Active efforts. So any party seeking to effect a foster care placement or termination of parental rights to an Indian child has to satisfy the court that active efforts have been made, and those active efforts are to provide remedial services and rehabilitative programs designed to prevent the breakup of an Indian family, and these efforts have proved unsuccessful. So it's different on non-Indian CPS cases. The department has to prove reasonable efforts. On Indian cases, you've got to show active efforts. What are active efforts? Lee is going to be talking a lot about that. But under the CFR, active efforts are affirmative action, thorough and timely efforts intended primarily to maintain or reunite an Indian child with his family. The agency must involve assisting the parents through the steps of a case plan and with accessing or developing the resources necessary. To the maximum extent possible, active efforts should be provided in a manner consistent with the prevailing social and cultural conditions and way of life of the Indian child's tribe, and should be conducted in partnership with the Indian child, the Indian child's parents, extended family members, Indian custodians, and the tribe. So it's very important to continue to work with the tribe, to locate the tribe as soon as possible and begin working with them. Next slide, please. Just more things in the CFR. I included this mainly just as a reference. These are all things that you need to do. I think it's especially important early on to, if you look at number 3, you're going to have the burden, CPS workers, of identifying, notifying, and inviting representatives of the Indian child's tribe to participate. And you need to, number 4, conduct or cause to be conducted a diligent search for the Indian child's extended family member, and contacting and consulting with extended family members to provide family structure and support for the Indian child and the Indian child's parents. Next slide. Just more examples of what needs to be done to prove active efforts. And let's go to the case scenario.
So now that we've heard all of this legal stuff, how do we put that into practice, right? That's exactly what we're wanting to get across today and to help as we're going through a case. So this is a totally made up scenario. You receive a report of child abuse or neglect is received due to allegations of domestic violence and substance use. The report states that there are ongoing issues of domestic violence between father and mother. The report indicated that police were called out due to family violence, and both parents appeared to be intoxicated, possibly under the influence of alcohol and cocaine. They have 2 children, ages 2 and 7. So I don't know if I went through that too fast. What we're going to do is we're going to have different types of scenarios from this main scenario. So kind of remember that we have 2 parents, a father and a mother, ongoing DV and substance use, and police were called out, and we have 2 children that are involved. So during the initial interview, father states that he is Native American and is enrolled in a federally recognized tribe. He provides an enrollment card with a census number. After interviewing the family, you have concerns regarding the allegations. What do you do? So these are your questions. More than one may apply. So you have a father, he's Native. He says he's enrolled with a federally recognized tribe. He provides you with the enrollment card, has the census number. After interviewing the family, you do have concerns regarding the allegations. What is your next step? The next slide, please. Oh. Nice. So yes, you make a copy of the enrollment card and notify the tribe, and you start treating the case as an ICWA case, and active efforts start now. So when you're looking at the law, you're thinking, well, there's these, we're still investigating, you know, there's these allegations, it's very early on in the case. Why do we need to start now if it's not before a court? What is it that needs to be done? So the importance of having a tribe involved as early as possible is that active efforts do start as soon as you find out that the case is that the child belongs to a Native American tribe. In this case, right now it's the father. We haven't gotten into whether the children are enrolled or not. But it's important to start active efforts at this point, especially when we go on and we start discussing things with QEWs, qualified expert witnesses, and we're starting to look at if there is a removal, were active efforts made at the investigative level, and if this case was transferred to FBSS, were active efforts made at that part. So you absolutely start treating this as an ICWA case as soon as you find out that dad is Native American. What does this do also? If you notify the tribe now, our tribe, for example, we intervene in all of our cases that are out of state. So there may not be much that we can do. You simply send us a notice, you let us know, hey, we're investigating one of your families, it's out of town, let's say it's in California. There is very little we can do, but at that time, we already know that there is some type of involvement with one of our families. We can start kind of reaching out, creating a kind of like a family composition or a family tree, so that if, God forbid, it ends up in a removal, we're already starting to work with the agency and knowing what we need to do next to prevent our children going into any type of foster care. Next slide. So reasonable efforts versus active efforts. Like John said, we're going to be discussing this a lot, why it's so important. And so with just a couple of examples of reasonable efforts, you refer a client for services, you notify a client of an appointment, you give a very basic level of case management. Active efforts is just kind of taking the next step, going a little bit above and beyond. You provide transportation to a client, to services that they're referred to, you offer a better level of care. It's more of an intensive level of case management. And I really like the example that Teresa gave about simply, saying, hey, there's water, there's a cup in the cupboard, there's water, there's a faucet over there, you can get the water. versus showing someone how to serve themselves water. I thought that was a great example of what's reasonable and what's active. Active efforts would be arranged for the best fitting services and help families engage in those services. So it's very family oriented. Next slide. The case scenario continued. After interviewing the family, it is determined that the case will be transferred to Family-Based Safety Services, FBSS. What are some examples of active efforts at the investigative level? You give a list of numbers for substance use treatment. You help mother and father make appointments for substance abuse treatment. Ask parents if they have transportation. Provide transportation to appointments if needed. Give bus passes for transportation. And like the other questions, there can be more than one answer.
Leah, for this one, we're just going to have people put their answers in the discussion forum for you.
Okay.
And Jocelyn will go ahead and tell you what their answers are.
Perfect. Can we actually go to the next slide, because we do have more answers as well if we're going to do it that way. Oh, I guess we gave you the answers a little early. That's okay. We'll still give, so we can go on to the next one. We actually divided this, provided a little bit more examples of reasonable and active efforts. So if we can go on to the next slide.
All right.
Other examples.
This one we can launch the poll question for.
Okay, perfect. So before we launch the poll question, again, it's the same question. It's the case is about to be transferred to FBSS. What are some examples of active efforts at the investigative level? Provide number to domestic violence shelter for mother and children. Ask father to leave the home. Help parents make appointments for domestic violence services. Invite a tribal representative to a family team meeting if one is conducted.
We've got about 30 seconds and about 30% of you have voted. So we encourage everyone to participate in the poll. Talking to myself. Your results are on the screen, Leah. You have about 53% said invite the tribal representative, 39% help parents make appointments, 4% ask the father to leave, and 3% give DV shelter, give number to DV shelter.
Awesome. Great job, everybody. So for those, you can see that the ones and the majority voted correctly. We could go to the next slide, please. So between those two separate questions, we're kind of looking at what the difference is between reasonable and active efforts. So giving a list of numbers for substance use treatment, I mean, definitely helpful, but when we're looking at active efforts, it's helping the parents make the appointments. Sometimes there's, you meet your client where you're at, right? So if they're not ready. They may not have the number, they may not have the resources, they may not understand, you know, like our parents with lived experience that were speaking earlier, they were so lost in the system just when someone showed up. So you give someone a number and they may not feel like they're ready, or they may not understand what it is that you're wanting. So helping them make those appointments. Provide number to domestic violence shelter for mother and children. Another example of reasonable efforts, ask father to leave the home. Understandably, those kind of things might need to happen if there's a safety plan that's put into place, but those are reasonable efforts. That's not active efforts. What are you doing next to help the family? You're explaining to the father the safety concerns and why he's needing to leave the home. Asking parents if they have transportation, that's a very important question. Assuming that a parent can make it to an appointment should not be an assumption that we're making. Asking them what's next. So kind of going on to the active efforts, the next thing might be giving them a bus pass, helping them with a bus schedule, showing them routes, providing transportation to them if it's needed. Like I said, helping parents make appointments for whether it's domestic violence, substance use, whatever services it is that they're asking for. Invite a tribal representative to a family team meeting if one is conducted. This one is very important. One of the things I do want to say, there's way over 500 federally recognized tribes. And so I obviously have not met or worked with tribal representatives in all of the federally recognized tribes, but I can tell you that I've been very blessed to be able to meet tribal members throughout all of Indian country. And everyone that I meet, they want to be involved. They want to be involved with their families and with their children. Some tribes are able to have more of an active role, and other tribes they may not have the staff where they're not able to be. Simply calling them one time, maybe, you know, they're overworked and they're not able to get an appointment, but they want to be involved and they want to be there. So simply making those phone calls, sending those emails, sending a letter, whatever it is that needs to be done, all of the above, I can tell you that every tribe that I have ever come into contact with, every representative, they want to be involved, and any little thing that they're able to do to be involved with their families, they would gladly be a part of if they're able to. So definitely inviting them.
Leah, this is Jocelyn. I just want to pose a question that came through because I think it's relevant right now to answer. Sorry to interrupt. The question is why do you have to do active? Oh, sorry, hold on, my screen just jumped. Why do you have to do active efforts in FBSS since it's not a foster placement or adoption? Doesn't ICWA only apply if foster placement or adoptive placement is present?
That's a great question, and that's something that John and I are going to highlight on a little bit later in the presentation, but I can definitely answer the question right now. At a 262 hearing, when there has been a removal, you have to have qualified expert witness testimony. And John will touch on that a little bit later on. But one of the questions for a qualified expert witness is, were active efforts made to prevent the breakup of an Indian family? And so when you're looking at everything that we're doing from the very beginning, starting from the investigation, starting from FBSS, what is it that you have been doing to help this family so that we're not having to remove children and place them into foster care? So that is the reason why active efforts start before, even though it's not a technical ICWA case. I'm so sorry. But that's definitely a question that's going to be asked of a qualified expert witness.
And it's also going to be asked of the caseworker. As a lawyer asking those questions, when we get to the 262, if the caseworker has not been making active efforts, the investigator hasn't been making active efforts, as a attorney involved in those hearings, I'm going to give it to him at the hearings.
Perfect. Thank you.
You're welcome. We can move on to the next slide. Okay. During the initial interview, father states he's possibly Native American and believes he may be Pueblo Indian. You have serious concerns about the safety and well-being of the children. You attempt an out-of-home placement to no avail, and this case leads to a removal. What do you do? Nothing. He doesn't have an enrollment card. Nothing. He doesn't know which tribe he belongs to. Notify the one Pueblo tribe in Texas. Notify all Pueblos and the Bureau of Indian Affairs Regional Director. Collect as much family history as possible with names and dates of birth and send the information to all Pueblos and the Bureau of Indian Affairs Regional Director.
We have 15 seconds left for those of you who have not voted. We have 95% said get family history, 59% notify all Pueblos and BIA, 30% notify the Pueblo in Texas, and 0% for both of the first two.
Awesome. We have awesome participants. So definitely, I mean, all the other ones apply, but number 5, collect as much family history as possible with names and dates of birth. Send the information to all Pueblos and the Bureau of Indian Affairs Regional Director. Family history is important. Sometimes people may not know, and some people who are not very familiar with Native American customs. I mean, we have been able to enroll people because of ICWA. And when we really talk about healing families, when we've had the pleasure of being able to bring families down and have them participate in their first feast day ever, and dance and be a part of the fiesta, because an ICWA case, a case came to play and they called the tribe and we were able to enroll the child, and we got the family reunified, and we were able to do that and really be able to see true healing happen is such a beautiful thing. And so family history is important. Getting dates of birth when we're sending names over to our enrollment department to find out if a person is enrolled in our tribe or is eligible for enrollment in our tribe, then getting as much history as possible is what helps us to make that part happen. One of the things I do want to say here, this isn't actually part of our presentation, but I thought of it right now when I was reading this, is if you have a family who maybe has history, let's say CPS was involved when the child was a newborn, and at the time, let's say mother is an enrolled member of a tribe, and at the time the child was not eligible for enrollment because the child was what was considered a descendant. In our tribe, we have been able to get rid of the blood quantum. Several years ago, there was a blood quantum, and so some of our members were not technically eligible for enrollment because of the blood quantum. Since then, thankfully, we have been able to get rid of that, and so now the child who, let's say 10 years ago, was not eligible is not only now eligible, but they may now be enrolled. So if you're looking at family history, please do not make that assumption that just because in the past they were not eligible, there are things that can change. So it is important to ask every single time, because like I said, sometimes things can change. In our case, thankfully, that's been able to change. And so if we have someone who's just looking at case history and is saying like, oh, well, back, 10 years ago, we notified Isla del Sur and they were not eligible for enrollment. So we're just not going to ask them because we already know that. Please don't make that assumption, because there are things that do change. So just wanted to put that out there.
And Leah, we actually had that case this summer. I had a court case where CPS made the assumption that because mom was a foster child in foster care and didn't say she had Indian heritage then, and because mom, when her last children were in foster care, didn't say she had Indian heritage, the department just decided not to look into it, decided not to notify any of the tribes that she said she was a part of, and the judge did not grant determination, and the case was extended so that they had to comply.
Thanks for that, John.
So you've gone through family-based services or investigation, and the decision has been made to remove the child from the parents. So we need to have a 262 removal hearing. So the first thing that needs to happen when the actual hearing takes place, according to the CFR, is the state court must ask each participant on the record. And who is a participant? It's not just the parents, CPS. I would say the parents, CPS, CASA, lawyers are participants. I think the court needs to ask each participant on the record whether the participant knows or has reason to know that the child is an Indian child. The CFR says that the inquiry is to be made at the commencement of the proceeding, and all responses should be on the record. Then the court also has to instruct the parties to inform the court if they subsequently receive information that provides reason to know that the child is an Indian child. So one of the things, caseworkers, when you're testifying, this is one reason that we need to comply with ICWA even before this stage, is because lawyers like me are going to be asking, well, when did you have reason to know? You've had this case, Mr. Caseworker, Mr. Investigator, for a month, and why wasn't that one of the first questions that you asked was, is the child an Indian child, so you could be working on placement? So that needs to not only be asked at the court hearing, it should be asked as soon as the case starts. Once it's determined that there is reason to know that the child has Native heritage, then notice has to be sent out. And was the notice compliant with the statute? Next slide, please. The statute specifically says that it's got to be done by registered or certified mail. But the state's burden, the agency's burden, is also to prove that active efforts were made. So lawyers, judges, you need to be asking the CPS witnesses, were active efforts made before this removal to provide remedial services? Part of that is going to be, was there a diligent search for the child's extended family? And how did CPS timely identify, notify, and invite the tribe? And as we know, these hearings tend to come very rapidly, and you've got to have a removal hearing within 14 days. So if you haven't notified the tribe before the child is removed, you're going to have a hard time. You may have a hard time at the 262 proving that there were active efforts to notify the tribe and to look for all possible placements. I think all lawyers, the CFR is great in terms of active efforts, and it gives you a laundry list of things that you should probably ask the caseworker. What were the active efforts? Were they designed to prevent the breakup of the Indian family? Did CPS timely identify, notify, and invite the tribe? Did they work with the tribe? Were tribal resources accessed? Was there a diligent search for the child's extended family? Were the extended family contacted and consulted? Was there a comprehensive assessment conducted? Appropriate services identified? Did CPS actively assist the parent in obtaining the services? Were the services culturally appropriate, and were family preservation strategies used? What steps were taken to keep the siblings together? Were regular visits with parents in the most natural setting possible provided? Were community resources identified? And did CPS assist parents or the family in utilizing and accessing these services? And again, you've got to remember that active efforts is more than reasonable efforts. Non-Indian cases require reasonable efforts under the Texas Family Code, but these Indian cases, you have to show active efforts. Next slide, please. Burden of proof. At these 262 hearings, it's not the same burden of proof in ICWA cases as non-ICWA cases. In non-ICWA cases, you just have to show evidence sufficient to satisfy a person of ordinary prudence and caution that there's an immediate danger to the physical health or safety of the child. The burden of proof on a 262 in an ICWA case is very different. It's got to be clear and convincing evidence. The same standard that you use for termination in non-ICWA cases applies to these 262 removal hearings in ICWA cases. It's got to be clear and convincing evidence that continued custody is likely to result in serious emotional or physical damage, not just immediate danger, but serious emotional can't even talk. Serious emotional or physical damage to the child. So it's a tough burden to meet, and this is one reason that efforts need to be made even before the 262. And this is something that lawyers and the judge need to be asking in every single case. Was there clear and convincing evidence? And was it likely to result in serious emotional or physical damage to the child? Let's go to the next slide, please. Qualified expert witness. This is something that I think we have forgotten in a lot of our CPS cases. Not only does this rule apply to termination cases, this rule under ICWA applies to removal cases. You've got to find a qualified expert witness. So again, CPS workers, if you haven't been making active efforts, if you aren't asking at the beginning of the investigation whether the child is a native child, it can be difficult to obtain a qualified expert witness if you're still trying to determine, if you're still trying to make contact with the tribe, if you're still trying to determine what tribe the child is a member of. Because a qualified expert witness has to be qualified to testify that continued custody is likely to result in serious emotional or physical damage. And they've got to be qualified to testify as to the prevailing social and cultural standards of the Indians tribe. The best expert is someone designated by the tribe as being qualified. Most tribes have somebody who they've designated, or some people that they've designated as qualified expert witnesses. And so it's important to work with the tribe, to work with them early on, and to find out who those qualified expert witnesses are so you can talk to them about the case and you can get them to testify that continued custody by the parent is likely to result in serious emotional or physical damage. You can request assistance from the tribe or the Bureau of Indian Affairs. You've got to remember the child's regularly assigned social worker cannot serve as the qualified expert witness. So if you were the investigator or the worker, you can't be the qualified expert witness. You actually have to find somebody who is a qualified expert witness. Leah's had some cases where they weren't happy with what she was going to say, and she's the Pueblo's qualified expert witness, so they try to find somebody else. So if the person is not designated by the tribe, the person that CPS is trying to use as a qualified expert witness, the judge and the parties involved need to question the credentials and the knowledge of this witness. I think anytime there's a qualified expert witness, all the lawyers need to be asking, are you really familiar with the prevailing social and cultural standards of the tribe? If they're not an employee of the tribe, if they're not a member of the tribe, how are they familiar with the prevailing social and cultural standards of the tribe? Is it enough that they just read it online or they read a book? No, they've got to be qualified to testify as those. So it's important to get the right qualified expert witness. Let's go to the next stage.
Actually, John, if I can interject for just a minute, real quick, while we're on the topic of QEWs. Like John said, that we've had some issues in some various states where they've tried to seek their own qualified expert witness just because they don't like what my testimony specifically is going to be. One of the best practices, I think, for state and county attorneys is we have dealt with other, there have been some states that just, it appears that maybe they don't like ICWA, they don't know ICWA, and so those are the ones that we maybe have a little bit of issues with. But some county attorneys have actually personally reached out before. They go over some of, whatever's in the court orders or the affidavits, and they ask us, do you feel like we're doing active efforts? If we are not doing active efforts, can you help us with that? Because we do have some serious concerns with the family, and this is what we're trying to do. And so one of the things I think that's important to remember is tribes do want to be partners. I cannot speak for all tribes, and I am in no way speaking for all tribes. There is no cookie cutter way of working with tribes. Every tribe is different. So understanding what their practices are. Some tribes do not believe in termination of parental rights, and they will not testify at a TPR hearing because that's not what their customs and their beliefs are. Some tribes, they know that some of their families do have some challenges and may need some type of interventions, and they want to work with states in helping to get their families the help that they need. Like Sheldon had said earlier, I think he had said 1 in 3 tribal members do not live on reservations, and so if their children are removed, they're removed into state custody. And so tribes do want to be partners, they do want to work, and when you're looking at qualified expert witness, we in no way are we wanting it to look as a burden or a hurdle. We just want to make sure that our families are receiving the gold standard type of care when it comes to child welfare, and that we can testify that active efforts have been made, that every single effort was made to prevent the breakup of an Indian family. And unfortunately, this is where we are. And so I just kind of wanted to throw that in there, that reaching out to tribes early on in the case so that you're able to meet with workers and talk to workers and just kind of find out where their feel is and what it is that they feel could be done for their families is vital in these cases.
And Leah would probably also, if they cannot get in touch with the tribe, especially if it is an El Paso caseworker, it might be smart of them to reach out to you or somebody at social services with the Tigwa tribe to see if you have any connections with a particular tribe or can assist or direct them, correct?
Absolutely. I've helped investigators. I've provided the list. We've provided them with contact information. We want to help our fellow tribal members in other tribes. And so absolutely, if they have any questions, they can most definitely give us a call.
And there's a great list under the resource list that y'all will get. There's a BIA website, and the BIA website has a couple different links to all the tribes. There's one link that will give you every tribe, the contact person, the phone number, the email address. There's another one that has a map that you can look up every tribe in a particular area. You can do it alphabetically. So all those resources are available. Check out the BIA.gov website.
And my email is at the end of this presentation. You will receive it on the list. My email has yet to be corrected. It does need to be changed, but just to know that on the list, my email is incorrect.
All right. So the next part of the 262 is the placement of the child. So placement preferences are vitally important, and the court has to follow these placement preferences unless there's good cause. The first place is members of the child's extended family. Extended family is very important, and it's also different. We might think of an extended family as just maybe grandparents, brothers, and sisters. But extended family under ICWA is defined by the law or the custom of the Indian child's tribe, or in the absence of such law or custom, a person 18 or over who's a grandparent, aunt, uncle, brother, sister, brother-in-law, sister-in-law, niece or nephew, first or second cousin, or step-parent. But it's important to talk to the tribe and find out how they define extended family. And it's not just their laws, but their customs. And remember, customs are typically not written. A lot of Native communities, most of them carry on an oral tradition. And so it's important to talk to the people in the tribe and see what they consider extended family. Is it any member within the clan? Who knows? Every tribe has different customs, and it's important to contact the tribe. But the first preference is member of the child's extended family. The second one is a foster home licensed, approved, or specified by the child's tribe. So some tribes and nations license their own foster parents. Some of them work with different agencies, and they'll have foster parents that are available to them. But that's, if you can't place the child with a member of the extended family, then you need to look at the foster homes that are approved by the child's tribe. If that doesn't work, then you go down to the Indian foster home licensed or approved by the state or non-native licensing authority, or in 262 or non-adoptive placements, institutions for children approved by an Indian tribe or operated by an Indian organization that meets the child's special needs. Next slide. On to case scenario.
Case scenario continued. So remember, mom, dad, DV, substance use, 2 children. After removal, children are placed in a non-native foster home. However, a pueblo in New Mexico has responded to the ICWA notice stating these children belong to their tribe and they have a foster family in New Mexico. What are some possible next steps? Include tribe in process prior to them filing a motion to intervene. Start the process for an ICPC. Object to an ICPC because the parents are in Texas. Have a discussion with foster parents about ICWA and ICWA preferred placements. Wait for the tribe to file a motion to intervene.
We're at 15 seconds left for those of you who have not voted. So it appears that we have 84% who said include the tribe in the process prior to filing. 57% start the process for an ICPC. 2% object because we're in Texas. 51% have a talk with foster parents, and 8% wait for the tribe.
Awesome. I think the next slide. So there were several. Include the tribe in process prior to them filing a motion to intervene. So under ICWA, a tribe has a right to intervene at any point in the case. They do not have to intervene Like I said, there is no cookie cutter way of working with tribes. We just started our practice of filing a motion to intervene in all of our cases a couple of years ago. Prior to that, we didn't file in a lot of our out-of-state cases. That doesn't mean that tribes don't want to be involved. That doesn't mean that they don't want to know what's happening to their children. There could be several reasons why tribes do not file motions to intervene. But for whatever the reason, including the tribe is a great next step. Starting the process for an ICPC, most definitely.
Can I interject there real quick, Leah?
Of course.
Okay, a tribe can intervene at any point. This was actually a case that we have in El Paso. We had in El Paso, and is still ongoing. But the tribe, definitely not our tribe, but another tribe didn't intervene and did not indicate that they wanted to intervene until the middle of the final hearing. Are they allowed to do that? The Texas rules of civil procedure, basically you've got to file at least 30 days before a trial. But under ICWA, they can intervene at any time, including the actual final hearing. So the termination was reversed because the tribe was not allowed to intervene, even though they waited to intervene until the final hearing. So it's important to remember that that is their right under ICWA. They can intervene at any point of the proceeding, even if they wait until the final hearing. And it doesn't have to be written either. They can just say on the record, as they did in this case, I want to intervene, and that's their intervention.
Yep. Thanks, John. Start the process. I'm sorry?
Sorry, because this question relates directly to this slide, I want to pose it now to you since y'all are on this. The question is an ICPC required prior to placement in the extended family placement out of state when we're talking about the tribal placements?
It's a good question. I don't know the answer.
Yes.
So, okay. Object to an ICPC because the parents are in Texas. No, have a discussion with foster parents about ICWA and ICWA preferred placements. Absolutely. This one is very important. ICPC, it may or may not happen. We had a case in another state where mom was incarcerated but was able to still have visits with the child, and so were the grandparents. And we agreed to deviate from the ICWA preferred placement and left the child in a non-native foster home because the child was still able to have visits with mom and with grandparents, and we're able to bond and everything. So we just continue to have those conversations with the foster parents that we're only deviating from the ICWA preferred placement because we want the child to be able to have visits with the parent, and bringing them to Texas would not allow for that. So there is good cause to deviate in some cases. Doesn't mean that every tribe is gonna choose that. Some tribes may wanna automatically honor the ICPC and have their children back home on the reservations while their family gets better or their parents get better. So it just varies, but definitely having those conversations with foster parents early on. In that particular case, every time that we had court, I made sure to put on the record that that was the only reason why we were deviating from the ICWA preferred placement, and really working with our foster families to make sure that they understand ICWA and that they understand what our kids mean to us and why it is that we're having them stay in the home while parents are engaged in services or while they're incarcerated in this case. And just FYI, in that case, we had a very successful reunification. We were very proud of that case.
And Leah, it's very important, isn't it, for when children are placed with non-Indian foster parents, it's important for CPS and everybody to be real honest with the foster parents about the placement preferences and the fact that it's a foster placement. It's probably going to be temporary. The placement preferences are always going to take effect over regular, I guess, preferences. So it may make it very difficult for non-Indian parents to adopt these children in foster care, and being realistic with them about their ability to adopt these children, and how the preferences are going to mean that we are working to find people other than them to permanently place the child or children with. Those expectations need to be set from the beginning with foster parents, correct?
Absolutely. And I would even go further to say not just setting the expectations at the beginning, but continuing to have those conversations. I mean, we are very grateful for foster parents out there who take care of our children, especially while we're trying to help parents get better. And so developing that relationship and continuing to have those honest conversations with them. You know, we had a case at one point, though obviously these cases, any case, right, any child welfare case, especially when they're in the foster care system and foster parents are very loving and very engaged and become attached to the children, it becomes very, very difficult, right? And we had one case at one point where it was really hard. You know, the child was starting to, or was bonding with the foster parent. We weren't sure if reunification was going to happen. There were some hiccups in the case. And I remember having a conversation with one of my social workers who's actually a tribal member. And she's like, oh my gosh, this is so hard because, you know, that day in testimony, I was saying if reunification doesn't happen and we terminate the parents' rights, we want to bring our child home to Texas. That is what we want to do. And this child had been in this foster home for over a year. So I was having a conversation with one of my social workers, and she's like, this is a tough one, you know, and she was encouraging her parent to, come on, like, let's do this, you got this, let's get your child home. And she's like, this is so hard because I've met the foster mom, and she's very engaged and she loves this child, and this is a tough decision. So I asked her, I said, you know, you're a tribal member. If this were you and you had a chance to be raised out of town in a loving home, right, by a non-native person, or you had a chance to come home and be raised on the reservation and participate and dance and do everything that you had the opportunity to do, what would you choose? And she said, if I had the choice, I would choose to go home. And that would be hard, but that's what I would choose. And so those are important things to remember, that a child did not choose to grow up outside of the reservation. A child did not choose to grow up in another state. For whatever reason it is that their parents left the reservation, that was not the child's decision. And so who are we to keep their child away from who they are and what's in their blood and what's in their heart? So yeah, definitely ongoing conversations with foster parents and helping them understand what it means to tribes to keep their children.
And it's also important for the foster parents to be in contact with the tribes so they know the cultural traditions. They know some tribes have things that are taboo that they feel will hurt the children if the children engage in. Some have rules about hair cutting, fingernail clippings, things like that. So it's very important for the foster parents to be put in touch with the tribe so they can learn all those things and act appropriately with the children while the children are in their care, correct?
Absolutely. And other needs that are being met. We've had cases where CPS workers are questioning us, like, why do you want their number? I don't know if you should call them, like, why do you want to be involved or whatever? And once we're involved and we're able to interact with foster parents and provide that extra level of support, they're super grateful, and you know, they open up their hearts and their minds to understanding not just the law, but understanding the tribe and what it means to the child. So absolutely. Like I said, tribes want to be involved in their kids and in their children's lives and in their families' lives, even from afar.
I have one last question about the ICPC before you, we always have lots of questions about ICPC. Just a quick one, John, is ICPC required if the placement is oh, sorry, my question just jumped from me. Is ICPC required if placement is licensed and approved by the tribe? Licensed or approved?
Yeah, you still have to follow state law on these cases, because there's not a federal preemption on this. There's no federal law that says that it doesn't apply. So ICPC is going to apply anytime there's a court action. I mean, we've had a few cases over the years where a 262 is filed, and before the court grants the 262, we have a mediation and we work it out so that the people out of town are given custody by the parents, or the parents send the kids on their own volition with the kind of tacit approval of everybody involved out of state. If that's the case, if it's the parents sending or the out of town people get custody before the 262 is granted, and that can happen like if the relatives file an intervention and they ask for custody, so they're given custody instead of CPS. If that's the case, then ICPC doesn't apply. But if the state is getting custody, the state agency, then ICPC applies. And even though it's a native foster family or native extended family members, you still have to go through the ICPC.
I do want to add also about ICPCs. It is important to, whenever you're sending an ICPC to another state, especially if the tribe is already involved, to include that this is a native family. We had an ICPC come in from another state once. We have built and fostered a great relationship with our local CPS here. And I had been, kind of bugging our liaison, hey, any updates on the ICPC, any updates? So he had been keeping track of it for us. The ICPC worker did not know that it was one of our children and had started the process until our liaison had called. And that kind of helped us kind of speed up the process a little bit more to get the children back to dad. It was actually a placement with father here. But that was something that was really important. She had no idea that that this was one of our children, and had it not been for our relationship with our liaison and him helping us with that, that could have taken a whole lot longer because they helped us with that piece. So identifying that would be awesome.
Thanks to you both.
Can go to the next slide. So case scenario continued. Parents are engaged in services. They attend their weekly visits with their children, and visits are going great. Father continues to work and sometimes misses appointments because of work. Mother's not working but expresses she wants to go back to school. They've completed individual therapy. Father completed BIP, mother completed domestic violence services, and both successfully completed outpatient substance abuse treatment. Things are going well. However, at the last home visit, there was tension between the parents. You still have concerns about domestic violence, and father reported that sometimes mother triggers him to want to drink. So this is case is going really well. Parents have been engaged, but there's still some concerns that need to be addressed prior to reunification. So what is it that you can do to help this family at this point, I think is our next. So what are some active efforts at this level? Help mom apply for school and financial aid. Talk to parents about concerns and tell them to talk to their therapist about your concerns. Ask father about a sponsor or peer recovery. Ask him to follow up. Then follow up with father and his sponsor and or peer recovery coach. Give them the number for ongoing services through a local domestic violence agency. Schedule a family meeting to include providers to see what else can help the family to be successful for reunification.
You have 15 seconds left if you have not voted. So it appears that we have 95% for schedule a family meeting, 66% for help mom apply for school and financial aid, 57% for talk to parents, 67% about ask father about sponsor and recovery, and 31% give them a number to local DV agency.
Awesome. We can go to the next slide.
It's taking just a second. They're looking at the answers.
Oh,
Well,
okay.
they will be in a second.
Well, that's fine. I can actually start talking about it. So if we're looking at talk to parents about concerns and ask that they talk to a therapist, that's great. I mean, you want to help parents become self-sufficient. You want to encourage them to be able to speak up and to know what to do next. That is most definitely a reasonable effort. When we're looking at something more, when we're scheduling a family meeting to include providers, that can kind of be what helps providers, especially therapists. We know that in therapy, a lot of it is what's self-reported. When we're including them as part of the team, and in that way, we're engaging the whole family and we're explaining kind of what the concerns are, and we're doing this from a holistic approach, and we're making sure that we're providing wraparound services. That's what makes it active efforts. Our goal is to never be involved in families' lives in this setting again, right? We don't want them to keep coming through the system. Being in the system is traumatizing. We heard it earlier from our panelists, just talking about what it was like to have to go through that. Our goal is to have them come in and not have to go through this again. There's going to be hiccups. We're trying to teach them to be self-sufficient and learn and heal, really, right? Being able to heal from whatever trauma it is that they've been through. So help mom apply for financial aid and for school and for financial aid, definitely an active effort. Ask father about a sponsor, peer recovery, and ask him to follow up. Then follow up with father and his sponsor or peer recovery coach. So we've had a lot of questions or a lot of comments with some of our, particularly I think some of our dads. We have seen a great increase of dads that are just really wanting to be involved. And a common thing that we hear from parents is just how lost they feel. And sometimes they do kind of just go through the motions. So when we're talking about active efforts, it's asking them, did you ever get a sponsor? Have you done peer recovery? What is it that you're doing to follow up? If you're feeling triggered, we're glad that you're acknowledging that. What are you doing to make sure that that you don't slip or there's not a relapse? Asking them what their relapse prevention plan is. Just visiting those kind of things with the parents to help build on the tools that they were given when they were going through treatment. One of the things that was not on the poll, because we could only have 5 questions on our poll, was follow up with therapists about possible family therapy. So in the second question, answer, it's talk to parents and have them talk to therapists. An active effort is the workers reaching out to the therapist and expressing what those concerns are. Ideally, more a family meeting if therapists or any of the providers are open to that. But even you as a worker, just calling the therapist and saying, this is kind of what I noticed, this is what the parent said, what can be done next?
All righty, so reasonable or active efforts have not worked. And we find ourselves at the stage where there's going to be a termination of parental rights. So if it's a voluntary termination, ICWA, again, is very different ICWA cases than non-ICWA cases. In non-ICWA cases, you can have the parents sign a relinquishment as long as it's in front of 2 witnesses, and in the form in the Texas Family Code, you're fine. Under ICWA, it's very different. It's got to be signed, recorded, and certified before a judge rather than just 2 witnesses. So you actually need to have a little certificate at the bottom of the relinquishment for the judge to sign, and the judge needs to go over the relinquishment with the parent not detail by detail, but they need to certify that the parent has read the relinquishment, that they understand the terms and consequences in full detail, that the parent understands the explanation in English, or that it was interpreted into a language that they understand. So does that also apply to non-native parents of an Indian child? Yes, the statute says any parent is the biological parent or parents of an Indian child. So it does include a non-Indian parent. So a non-Indian parent still needs to, can we go back one? The non-Indian parent still needs to sign his relinquishment in front of the judge. And it's got to be certified. You also got to remember on the, can we go back one more? On the voluntary termination, or the voluntary relinquishment, it can be terminated anytime before, the voluntary relinquishment can be taken back, withdrawn anytime before the termination. That's not true in a typical CPS non-ICWA case. In the non-ICWA cases, the relinquishment is going to say that once it's signed, that's it. So that needs to be a little different language in the ICWA relinquishment, telling them that they can withdraw their relinquishment at any time before the termination. So realistically, for practice, what that means is what we try to do anyway in El Paso is once the parent signs the relinquishment in front of the judge, we try to have that termination trial immediately so that it can't be withdrawn and that the termination is final at that point. So now if we can go to the next slide. So where do we go if it is a non-voluntary termination trial? We again, the CPS is going to have to talk about the reason to know, was the notice sent, and then were active efforts made by the worker to prevent the breakup of the family, the breakup of the Indian family. And you'll basically go through lawyers and ask the same kind of questions that you were asking to ensure that active efforts were made before this termination. And then if we can go to the next one. The burden of proof for a termination is beyond a reasonable doubt. In a non-ICWA case, it's clear and convincing evidence. But in an ICWA case, it's beyond a reasonable doubt, the same standard that is required to convict somebody in a criminal case. And again, it's not just that there was a danger, an immediate danger to the child, but that continued custody is likely to result in serious emotional or physical damage to the child. And again, at a termination trial, you've got to have that qualified expert witness testify that continued custody is still likely to result in serious emotional damage to the child. Can we do the next slide? So let's talk about adoption. So the rights are terminated. There's going to be an adoption. The placement preferences are mostly the same for an adoption, except the institution part there was number 4 and the other one is taken out. So the placement preferences are members of the child's extended family. So the extended family is very important. Foster home licensed, approved, or specified by the child's tribe, or the Indian foster home licensed or approved by the state or other non-native licensing authority. One last thing about court things, if we can have the last slide, that I think is just interesting about the ICWA cases is at some point in the future, even if a parent's rights have been terminated, if the adoptive parents later have their rights terminated, a biological parent, even though their rights have been terminated, can petition the court for return of custody, and the court has to grant it unless it's not in the best interest of the child. So even though the rights have been terminated, parents still have a right should something happen to the foster parents and the foster parents' rights or adoptive parents' rights are terminated in the future, whether they relinquish or go through a termination hearing, the bio parent can petition for return of the custody. Another good thing I think about ICWA is the information available to an adoptee. I don't know if you have ever, if any other lawyers have tried to get information for people who are adopted after the age of 18. It's quite a difficult process in non-ICWA cases. You have to file a whole bunch of things, and sometimes you can make it work, sometimes you can't make it work. In ICWA cases, if it's an Indian individual, the court who enters the adoption decree shall inform the individual of the tribal affiliation of the individual's biological parents and provide such information as necessary to protect the rights flowing from the individual's tribal relationship. So.
Nice. So some best practices. Caseworkers must make several considerations when handling an ICWA case, including working actively to involve the child's tribe to provide intensive case management. Intensive is a key word there. I think we've said several times that tribes want to be involved as much as they possibly can. Providing active efforts to the family. I feel like we've totally drilled that in you guys, what active efforts is and the importance of active efforts. Identifying a placement that fits under ICWA preferred placement provisions and notifying the child's tribe and the child's parents of the child custody proceeding. Notification to tribes right now during this pandemic, I know it's challenging with some of the it has to be under the certified mail. In the beginning, last March, we had some that were crazy delayed. We didn't get actual notice until 2 months later. I remember signing one that was signed in May, and I think they had mailed it back in March. But picking up the phone during this pandemic, our department has not closed at all. And so picking up the phone and calling tribes, like I said, they want to be involved if they're able to be involved. So simply picking up the phone, looking up the registry, sending an email, just those kind of things to provide active efforts to the family. I know there's, especially for our caseworkers and social workers out there in social work, they, when we're talking about active efforts, we're talking about intensive case management. There's sometimes, I guess, this battle of never do more than your client. But that's not really what ICWA is asking us to do. Like Sheldon had said earlier, ICWA is a reparative law. We're really trying to heal a lot of the damage that was done. There's reasons behind the law, and unfortunately a lot of these things still exist today. And so it's definitely just meeting clients where they're at. I tell our wonderful team of social workers all the time, at the end of the day, go to bed knowing that you did everything in your power for your family or your families. And if they weren't ready, they weren't ready. If we get to the point of termination, it's not going to be because of anything you did or didn't do for the family. Do your very best. And that way, like John said, when the child turns 18 and they come back and they come searching, you're able to tell the child, this is what we did. And unfortunately, it didn't work at the time. And just like I said, go to bed knowing that you did the very best that you could for the family.
And I think regarding notification, it's important for them to know that even though the statute says it's got to be you've got to have registered certified mail, it actually does require more than that. If you're not getting, the statute specifically says it's got to be done by registered mail, but you've got to remember that active efforts under the CFR requires identifying, notifying, and inviting representatives of the Indians tribe to participate. So we had one of those cases this summer where the department called in March, and that was basically it. They sent the registered letters. They called right at the outbreak of COVID. They didn't send any emails. They didn't make any other attempts to contact the tribe. And so I objected at termination that active efforts weren't made. And when they made active efforts, they actually found a placement for this child. And so the case had started in August of 2019, but those active efforts weren't made to really reach out to the tribe in any other way other than just the certified letter and one phone call. And so that really isn't active. And unfortunately, in cases like that, this resulted in the child being in foster care for over a year. And once the active efforts were made, they found an Indian member of the child's extended family. And so they're working on trying to place the child with that extended family member. But that's a year of the child's life that he spent in foster care, when really those efforts should be made even before the 262, but definitely at the beginning of the case. And this child could have spent more time with the family. So there really are real life consequences to these things, and we need to ensure that these active efforts are made.
Okay, and in the interest of time, just review this slide. I think we've talked a lot about expert witness, qualified expert witness, and what it takes for an expert witness, but if we can go on to the next question, please. Active efforts were made to prevent the breakup of an Indian family. However, all efforts were unsuccessful. You are now at termination. What is needed at this level? A QEW, this could be anyone who has testified as an expert witness in an ICWA case. QEW, preferably one designated by the tribe. Proof that reasonable efforts were made. Proof that active efforts were made. QEW testimony that returning the child to the home would cause serious physical or emotional harm. Discussion with your QEW about why active efforts were or were not made. We'll go to the poll.
I'm going to cut this poll a little bit shorter in the interest of time, so you have 15 seconds if you have not voted. So we have a majority of participants saying 71% discussion with your QEW about active efforts, 67% QEW testimony to the harm of returning child, 75%, QEW designated by the tribe, 12% QEW could be anyone, and then 43% proof of reasonable efforts.
Awesome. So just remember, it's proof of active efforts, not proof of reasonable efforts. Preferably one designated by the tribe. In New Mexico, for example, all the pueblos in New Mexico are part of the New Mexico, there's a consortium. And from the consortium, there's a handful that are QEWs. And so the pueblos, it may not necessarily be someone from their pueblo, but allowing them to designate one of the people from the consortium who are a QEW, are familiar with the customs and traditions of the other pueblo, because they work together, not just because they know, oh yeah, we're one pueblo and so we operate the same way, because that's not at all the way that it happens. And then, like I had discussed earlier, discussion with your QEW about why active efforts were or were not made. Those are all important things that need to be done. Why it's important to collaborate: provides a better enhanced service delivery to families, allow tribal and state courts to work together. That wasn't really something we discussed very much. Some tribal courts will file motions to transfer immediately, and so that's important too in involving tribes. We do not have our own child welfare court or code, so we do hope to get to that at some point, but we do not transfer to our jurisdiction. Reconnect children to their native community. allow tribal children in foster or kinship care to learn their Pueblo customs, traditions, and history. So an example is with us, we every summer, with the exception of this past summer because of the pandemic, we do have a cultural camp. We do like to invite our kids right now more than ever in this whole virtual setting. More tribes might be able to offer services or those types of settings to their families. We do have one last question that might be cut very short, but who is responsible for asking family about Native heritage? Investigator, FBSS worker, CVS worker, attorney, or judge?
In the interest of time, I'm also going to cut this one a little bit shorter. You have about 10 seconds if you have not voted. So the majority of participants said CPI investigator, 3% said FBSS worker, 8% CVS worker, 5% attorney, 19% judge.
The answer is all of the above. It is important for everyone to ask. And also, like John has given different examples, not make the assumption that the person before you asked. That's why it's important for everyone to ask at all levels. Because especially the last example he gave of this child being in foster care for over a year, that may not have needed to happen. And so it's important for everyone to ask. We did include foster parents, not in the poll because we could only have 5, but also foster parents. It's not a legal responsibility for them to ask, but it is important. It's important for them to know if they have a Native child in their home, and for them to work with the tribe.
Thank you, Leah and John, so much for that informative panel. We had a lot of questions, as I put in the chat. There were some great questions, and we will work with Leah and John to try to get those questions answered and send out after the conference. Thank you so much again. We now have a 10-minute break. We'll be back. Well, we got about 8 minutes now. We'll be back at 2:55 for our case law update.